Hi there, this is Jonathan Ginsberg, and I'd like to answer a question about motions for relief from stay in Chapter 13. And the question is this: if a creditor, if a mortgage lender files a motion for relief from stay in my Chapter 13, what happens? How likely is it likely that I'm going to win? And what should I know about motions for relief in Chapter 13? Well, first of all, you have to understand what a motion for relief is, and that is a creditor, a mortgage lender, will file a motion for relief in the middle of your Chapter 13 if either you fall behind on your mortgage payments or if your insurance lapses. There could be other reasons, but those are the main two. And basically what the lender is saying is that you are not making payments, you're not providing insurance, therefore the lender's collateral is not being adequately protected. So they'll file a motion for relief, and they're asking the judge to lift the automatic stay so they can go ahead and pursue state law foreclosure relief. In other words, in Georgia, they would get the stay lifted, they would then start foreclosure proceedings, and then a month or two later, your house would be sold on the courthouse steps, it'd be foreclosed upon. So what can you do? Well, obviously, one thing you can do is nothing and simply surrender the property. And that would be appropriate if you simply don't have the money to make the mortgage payments, if you've lost your job or something significant has changed. The second thing is you could litigate the matter, and which means you would go in front of the judge and you would argue that the stay should not be lifted because, in fact, you've made the payments. And this actually has happened a couple of times over the years where my client has made the payments and the lender did not properly record them, and we went in front of the judge and said, here are the receipts, and here's proof we made the payment. And what happens then is that the judge will then turn to the lender and say, you need to research this because I'm looking at copies of canceled checks, and it looks to me like you're not giving this person proper credit. And that actually raises a very, very important point, and that is, while you're in Chapter 13, it's very important that you save copies of all your receipts, all your payments. So when you make your monthly mortgage payments, you're making them directly. Make copies of all those payments. Try to get some sort of receipt that it's been received, if it's return receipt, requested mail, or some sort of proof, some receipt, or at the very least a copy of the check showing it's been cashed. Money orders, by the way, are not nearly as good because it's very hard to trace a money order. So if you say, here, I sent the money order, and here's proof that they received something in the mail, that doesn't mean that you can prove that they received the payment. That would probably buy you some time, but a money order is much more difficult to deal with. So if you can show that you've made the payments, then you're in pretty good shape, and you can at least get the judge to put the burden on the mortgage company to argue that, in fact, they did not get paid or they didn't get paid the right amount. Most of the time, however, in a motion for relief situation, we're going to be able to negotiate some sort of a deal. And basically what that means is, let's say that you are 2 or 3 months behind in your post-petition mortgage payments, and let's say that turns into $1,500 or $1,800, that's what the equivalent is, or $2,000, pick your number. What the judge is going to expect the mortgage company to do is to work out a deal with you so that over the next 6 or 8 months, you cure that post-petition arrearage. My experience has been that judges are very reluctant to throw people out of their houses. They'll give you a second chance in bankruptcy as long as you're able to make some reasonable effort to pay it. And again, that would typically be over 6 months or 8 months, and there'll typically be some sort of a strict compliance on that, where if you miss a payment, the lender does not have to go through the whole process again. It can be done much more quickly with simply a letter and a verification that you've not made the payments. But there's usually a lot of ways to deal with a motion for relief from stay. You're not going to lose the house unless you want to, and you typically have a chance to either defend it or to work out some sort of a deal, because again, judges are going to most likely give you a shot at it if you did litigate it, and even if you hadn't made the payments. So big picture here is, if you get a motion for relief from stay, pick up the phone, call your lawyer, and say, hey, I got this motion for relief, the lawyer's got it as well, what can we do? And you talk about the various options out there and come up with a plan so that you can save your house, or if you're going to surrender it, that you surrender it. But either way, you know what's going to happen, and you don't show up in court the day of the motion for relief, and that shouldn't be the first time you talk to your lawyer about it. So talk to your lawyer early. Communication is really important, but rest assured there are plenty of opportunities to save your house. You get a second bite at the apple, so to speak, and we can usually negotiate something on your behalf to resolve the motion for relief from stay without you losing your house. Hope this has been helpful. Again, I'm Jonathan Ginsberg. Any questions, please let me know. Thanks a lot.